This is a non-payment case for possession only. We've got a rent to retain on this consent judgment in the amount of $330. Court costs in the amount of $182.04, giving us our grand total here today of $512.04. We've got language in paragraph 10 giving a payment plan breakdown. Defendants pay $100 on or before September 8th of 2025, with the remaining balance, September's utilities included, on or before September 30th of 2025. If paid timely, parties agree to stipulate to set aside this judgment and dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. The 56-day rule is waived. Defendant has added her signature to this resolution, and we did go over MCR 4.201J.
Okay, so you chose to do it as a consent judgment versus a conditional dismissal?
That's correct, but with the same outcome at the end of the day, assuming that it gets properly taken care of. Defendant simply has to email me to let me know that she's got the balance taken care of. We'll do a stipulated order to set this judgment aside and dismiss this case.
So this requires her to email you and you to get it dismissed after she pays?
Correct.
Why not your client? Why wouldn't it require your client to notify you that she's paid?
So it's just a responsibility that I've put on defendants for the past year or two. It's just a way of saying, hey, when you get this balance taken care of, reach out to me, let me know. And it also begins the stream of communication between myself and the tenant so that the tenant's aware of how this thing's unraveling.
There's a judgment then. If she's done what the agreement said and she doesn't reach out to you and your client doesn't tell you who they should have a responsibility, it should be put on them. She's paid in full. I need to see that the client needs to have some responsibility and not just the defendant, if judgment is going to enter.
So you'd like me to add in language that indicates that my client's to reach out to me once the defendant has.
Absolutely, they're the one receiving the payment. Don't you have to confirm from them?
Yeah, I'd be confirming with them anyway.
Correct, so that they should be notifying if she's paying full, not her.
So
she could tell you she's paid in full and she's not.
Correct, but this is the benefit that we're providing in the first place. It seems like providing this benefit would then result in the understanding that, hey, you just reach out to me to make sure we get this properly addressed.
I recognize what you're saying. This is a court that we have a eviction diversion program.
Okay.
And I recognize that's one of the ways that you're choosing to resolve this, but we also have an option to choose to do a conditional dismissal. You're still offering the terms of a conditional dismissal,
right.
Only that to the defendant's disadvantage, there will be a judgment up front against her. She's gonna, if she agrees to this.
Right.
Versus a dismissal, and then if she doesn't follow through, then judgment enters. And so now you're putting the responsibility on her to now reach out to you to tell you that she's paid, for you to then have to confirm with your client, when you can just have your client reach out to you.
Yes, Your Honor, just simply send me an email letting me know that she's got the balance taken care of. Is that too much in this instance, Your Honor?
I'm not saying that she shouldn't. I'm saying I want to know I want language that your client is going to reach out to as well. Okay. To make sure the responsibility needs to be also on your client. They have to confirm that they received payment.
Fine. So the language has been added. I do apologize, Your Honor. I thought that just putting the language in the first place was a nice show of respect and benefit as far as making sure that this can get set aside and dismissed. But I do understand you want a little extra padding into it. So I've added language. Property management is to email counsel upon receipt of full payment.
Yeah, I want extra padding because my preference in a court that does a diversion for eviction is to prevent people from being evicted. And so if I need her to just pay her rent so that she doesn't be evicted, I don't want to then put the onus on her to get the case dismissed after she does that. I want the responsibility on her to pay her rent. All the other responsibility to get the case dismissed, I want that on the attorney. I don't want it on her.
Understood, Your Honor.
I don't know if she'll have internet. I don't know if she'll have a working phone. I don't know what will take place to get her rent paid. What I want is to make sure that once her rent is paid, if she doesn't have a mechanism to email you, that you're still taking the responsibility to get this case dismissed.
So should it no longer then be a stipulated order?
What do you mean should it no longer be? Well,
the way that we set aside the judgment, dismiss the case would be with a stipulated order, which would require her to have some sort of communication with me in the first place. That's partially the reason that the email is kind of beginning that process of communication for us to get that properly drafted up. And so then we just submit an order that would set aside the judgment and dismiss the case, and it wouldn't be stipulated.
No, you're going to dismiss the case. It doesn't have to be stipulated. It could be, you can dismiss it in a number of ways.
Okay, so
It
it's
can be
submitted,
dismissed by plaintiff. It could be dismissed by stipulation. It doesn't matter to me how it happens.
okay, so,
If what you're doing is a reverse version of a conditional dismissal, she's gonna have judgment enter up front versus if you did a conditional dismissal, judgment would not enter in unless she failed to comply.
correct.
Then that's fine, but what I'm saying is that I don't want the onus to then be placed on her, that she could still pay her rent, but if she doesn't email you, this judgment's gonna stay on her record. That's what I don't want, because we don't know her circumstance and what she has to go through to get the rent paid. She may not even have a mechanism to email you at that point. She may have to let her cell phone be disconnected to pay her rent. She may have to let her internet go to get the rent paid. If she, ma'am, I'm talking, put your hand down. When the rent is paid, it should not be, I don't want it to be her responsibility. It should be your responsibility and your client's responsibility to, after she's done what she's done, which is to pay the rent, to get the case dismissed if that's the agreement. You pay your rent, we'll get it dismissed.
All right.
Is it relative to anything that I just talked about? Is that yes?
I don't owe them nothing.
So why in the world are we here in the first
I don't
place?
know. I'm sorry, I'm trying to be disrespectful. I don't owe them anything. I just signed my name to pay for something. I don't owe them anything.
Well, then you can't do that. What's the issue?
Um,
I'm talking, no, not for you. You don't have to prove your, he has to prove it. What is the,
I'm sorry.
It's supposed to be past due rent?
Yes, I don't owe them money.
So she had a rental portion for a period of time that was not paid, that in combination with late fees being added on, late fees being below $21 a month, in addition to the court costs and
No, it's not, ma'am. You have to relax. What is the amount that you're saying she owes past due?
so the rental amount that she's owing is $330, with the court costs is $512 and 4 cents.
And the ledgers, this is from late fees?
No, this is from her rental portion in addition to late fees.
Okay, so she's on section 8?
Correct. She's got a zero balance currently, but that wasn't always the case, or a zero rental rate currently, but that wasn't always the case.
Okay, when did it become the case that she had to pay? Or when was it that she was paying and then she stopped? What was her amount that she was supposed to pay?
So the last payment that I can see was back in November of 2024. And the rental rate at that time looks like it was $24 a month.
She was supposed to pay $24 a month back in 2024?
Yeah, back in November of 2024. And it didn't, her rental rate didn't drop to zero until, looks like June was the first.
Of this year?
Correct.
Okay, and so you're saying that she owed $24 and didn't pay in December, January, February, March, April, is that what you're saying?
That is correct.
Okay. Ma'am, is that your belief that you owe you paid $24 a month back then?
So I paid them $24 and I paid it up like, it was like, I had paid a bulk, like 160 or something. They said it was 24, but then they said it was 27. And then they said I was supposed to be paying 27, but I never knew that. I only knew the 24.
How is she notified of how much she's supposed to pay?
Good.
I'm asking him.
I'm not sure off the top of my head, Your Honor.
Where's
She's
the
provided me a
witness?
document of notification of that payment, so I know that she is getting notifications, but I don't have a specific one on me. I know that.
She's provided you documents of how much she's supposed to pay?
Correct.
And how much was it?
They said 24.
Okay, the document that you have it with you now? It says 24? Is that a yes? We're on the record, so you have to say yes or no.
Yeah.
But you don't have anything that says otherwise?
No, I don't have anything that says otherwise.
Can I?
Well, then,
say one thing?
no, ma'am, then I'd have to go with her amount. You don't have any evidence otherwise.
Right, but I just said that it's 24.
Yeah, so she's supposed to be paying, so where's the late fee then? She said she was paid.
So no, she paid back in November, but there hasn't been a payment since that time.
Did she make a lump sum in advance payment?
She made a lump sum payment, but it didn't zero out the balance.
When was that? And how much was it?
That was November of 2024, and it looks like one payment of $148 and then one of $60.
148 and 60, both in November?
Correct.
Was she behind when she made that payment?
Yes, she was, though there was an error that occurred in resulting in that. She went to regular rental rate back in May of 2024. That was removed from this balance.
Okay, who's your witness?
Here today for a trial.
This is a hearing.
So I don't have a client with me at this time, Your Honor.
So how are you gonna prove your case if you didn't have a client?
I expected to be able to get to a resolution. It's my understanding that when we set aside the default judgment, that the concern here was the 893. We removed the 893. We agreed that that was improperly placed on the ledger, and so we had to balance that. To my understanding, wasn't being questioned in the first place from the previous hearings that we'd had leading up to now.
I don't know where you got that from. This was set for a hearing.
Right, from a default judgment that was previously set aside on the.
I
previous
recognize that. They was set aside.
Correct.
We moved on past that.
Correct.
I found good cause of meritorious defense.
Correct.
That
I'm not
doesn't mean
arguing
that you no longer have to prove your case. And you can't prove it through your testimony. You're not a witness. You were supposed to bring your evidence and present it to the court. How are you going to present it? Because we have to have a hearing. She said she doesn't owe anything and you don't have any evidence. So the case is dismissed. You're all set.
The case is just.
Today is the date set for a hearing. You brought nothing for a hearing. You don't even have a witness. Is your client here?
No, my client's not here. Your Honor.
Do you have a client here for a hearing?
I did not, but I don't have a hearing.
Yeah, but if you were having a hearing, would you bring a client,
Yes.
Mr.
My
Dewar?
client's
Mr. Whitty, would you bring your client if you had a hearing scheduled?
I sent both of them away, so,
After you resolve, not before?
correct.
You didn't appear with a witness at all.
So it couldn't be adjourned. This isn't something that could be rescheduled
Today was the date set for a hearing.
after the default judgment.
You did not you've not request, if you mentioned one more time that a default was set aside, she had good cause and a meritorious defense.
I'm not arguing.
Yeah, so why do you keep bringing it up like I don't know that?
I assumed that what was addressed at that hearing was the 893 that needed to be set aside. We had then set that aside. I was under the
What
mistaken
happened
assumption
at that
we-
hearing was for her to provide me good cause and meritorious defense. I didn't hear any proofs about whether or not she owed money or not. That was what the hearing was for.
I understand. Thank you, Your Honor.
Thank you.